Hello, hello, my Cornell comrades. I am going over reps, warranties, and covenants within agreements. So, again, this is contract law, and just wanting to go over this with y'all. Okay, as support for me, for little old me. Let me see it. Do I have volume? I hope y'all can hear me. Let's make it louder. There we go. All right, now listen. It says to draft or review a business agreement, it's important to understand how the components of an agreement relate to each other. How they relate to each other. You must view the contract holistically. Okay, so this information. Okay, awesome. I just got a message from Tanner. Awesome, Tanner. Thank you so much. Okay. To draft or review a business agreement, it's important to understand how the components of an agreement relate to each other. You must view the contract holistically. This information is from Professor Whitehead. Okay, and so in this information, Professor Whitehead is explaining three principal relationships that exist between common components of a business contract: reps, warranties, and covenants. Okay. Oh my God. Help me, Jesus. Okay. So we're going to go through some of the important components of a business agreement, section by section. But you need to understand that contracts really need to be read holistically and in their entirety in order to understand how the different sections work together. You know what it reminds me of? Like terms and conditions. The one contract that all of us use and all of us typically accept, but very few people will read what is in those terms and conditions. Ain't that something? It's interesting. The different sections of a contract, they really work together. They interact with one another. And so for our purposes, there are three principal tie-ins that run across a business agreement that we really need to be sensitive to. The first is the relationship between reps, warranties, and covenants on the one hand, and the closing conditions, the conditions to closing on the other. The second is the relationship between reps, warranties, and covenants and post-closing price adjustments, in particular the indemnification. And the third is the relationship between closing conditions and indemnification itself. So, turning to the first, it's common for a closing condition to be that the reps and the warranties that were agreed to when the contract was signed remain accurate, or at least materially accurate, at the closing date. Now, let me tell you, that generally doesn't work. And I'm going to tell you why. Because during negotiation and things like that, information changes, right? The information changes. Like, say you write a script for a movie, and in your script you have certain things set. You have your character set, the setting is set, but then the producers, the ones who are going to give the money to produce your art, wants to make changes. It happens. So by the end of the time, when you have cast his wife as the love interest and his son as a son and his dog as a dog and his mama in a part and this, that, and the third, and he has a walk on, and all of these things that you have to agree to in order to get your project financed, and it's all in the contract. You have to agree to all this stuff. So what you went into, your understanding going into this business agreement is quite different than what you end up with. It's just one of the things that I thought about. So it says, a closing condition. It's common for a closing condition to be that the reps and the warranties that were agreed to when the contract was signed remain accurate, or at least materially accurate at the closing date. Okay? Otherwise, the beneficiary of those reps can simply walk away. And I've seen that. Walk away from the deal if it turns out that for whatever reason the reps or warranties weren't accurate again at the time of closing. The same is true for covenants. Covenants may cover the time between when the contract is signed and when it's closed, assuming there's a time gap between the two, addressing what's referred to as a moral hazard. Here we go. Now we get into the sticky icky part. The moral clause. Oh my God. Here we go. The risk that one or both of the parties to the contract, after they've signed the contract, will change their behavior sometime before the deal is done. So, for example, having now signed a contract to sell a car, you're selling the car to me, but before the car and the cash change hands, something happens. The seller may have less incentive to maintain the car in the way that the seller did before the contract was signed. Now, some amount of moral hazard is addressed through the reps and the warranties. There can't have been a material change in the car between the signing and the closing. Otherwise, the reps are no longer accurate at closing. But as the buyer, I may want something more, like maybe an affirmative covenant that the seller is going to maintain the car in the same way as the seller has in the past. And again, compliance with covenants is also going to be a condition of closing. This is the reason why we need contracts, because you think that people would just do what they're supposed to do, right? For some reason they don't. I don't know why, but they just don't. This is why we need contracts and agreements, so that everybody's on the same page and there is an understanding. Okay? A failure to comply with those covenants, if the seller fails to do so, is going to give me, the buyer, the ability to walk away, or at the very least try to renegotiate the terms of the deal. Let me give you an example. Say you're going to buy a vehicle. First thing you do is check the spare tire, check the engine. You look at the starter, the alternator, you listen, you take out the transmission thing, smell it. Does it smell burnt? Does it smell okay? Check the oil, see what it's like. Is it gritty? Is it newly changed? What's going on? Take the car on a test drive. Go by the Les Schwab. Have them to do a free road checkup on it. See what they say it needs, and thus and so. Then you take it over to AutoZone. Talk to the people over there, right? Normally, AutoZone will not check a vehicle unless there's a indicator that's on. If no indicators are on, then AutoZone, can't check anything. Did you know that? I just found that out myself. Listen. Also, Les Schwab's will do a free checkup on your car. Um, you may have to call to make an appointment before your road trip, but they will take care of that for you. So you do all of this. It comes back good. So you decide to buy the car. Well, while everything is being done, the seller takes off parts and puts on junk parts. Yes, he decides that he's going to change out the starter, the alternator, the battery, the spark plugs. He's going to change all of those out. Whereas before he had the actual primo stuff, now he is replacing all of that with uh um you know cheap stuff. Okay, so he only put all the new stuff on in order to sell the vehicle, for the vehicle to perform really good, pass all checks and everything like that. And so now that it's done that, he swaps out to all the old junk on the vehicle so that he can, either sell the new parts or recycle them so he can make more money. So not only is he going to sell the parts on the car that you have agreed that you would buy the car with it on there, but he's going to put junk parts on there or pick apart parts on the vehicle and then sell the actual parts to another person, make more money on top of that. So he has cheated you, and now he's going to make revenue off of parts that you paid for but did not get. So when you get into the car and it's running like this and you're like, what the hell is going on? This vehicle wasn't like this here, the other day. What's happening? So now what do? You take him to small claims court, right? Depending on the price of the car, right? So here's Professor Whitehead says, for example, I may have included fairly strict representations about the car's quality in the purchase agreement, but I want to make sure that these representations and warranties continue to be accurate. Really make these a condition to closing. I will not close if any of this changes. The same way with buying a house. Okay? I have this much in assets, but I spent 10 grand on, hiring a contractor to dig a pool in the backyard of the house that I don't even have I haven't closed on yet. Well, your assets has gone down now, lovely. Okay. A condition to my obligation to pay for the car if the closing is at some future date, because if I don't have ability to walk away, in fact, if the car, for example, has changed in value or changed in quality between the signing and the closing, and I don't have the continued accuracy of the reps as a condition to closing, I may end up still being required to close if it's not in the contract as is. You agreed to buy this here hunk of junk as is. As is means as is, boo boo. Mm. Ah. Thus, I may end up still being required to close, but with a car that's worth a lot less than what I thought I was getting at the time the contract was signed. Now, that takes us to the relationship between the representations, warranties, and covenants and the indemnification. Some contracts have a remedies provision that's in addition to or in lieu of regular contractual remedies. If there is an indemnity, the seller of a car may be obligated to pay me the resulting loss in value. From the breach of a rep or a warranty. It's important, however, to pay particular attention to the terms of the indemnity. Some indemnities may actually limit the party's remedies, making it clear that the indemnity is the sole remedy in the event of a breach, but perhaps limiting the ways in which the contract's value can be adjusted as a result of the breach taking place. So, even if there's been a significant breach of a rep or a warranty or a significant breach or of a covenant, if the indemnity is my exclusive remedy, and if there's a cap or some other limit on the amount that the seller must pay me, small claims court. I think the value in small claims court varies from municipality to municipality, but I've heard that you can sue for like up to 10 grand in some places, which is a good deal for small contracts. I may not get the full benefit of the rep or the warranty or the covenant. I may be stuck in this case with a car that's worth a lot less than what I first thought. That's why a lot of people, they don't buy vehicles off the side of the road or Craigslist. They actually go to a dealership to try to get out of this. But then at the dealership, honey, they do their little stuff too, honey. Yes, they do. I just thought of something. Purchase agreements. Yeah, the first thing that's coming up is purchase agreements, simple purchase agreements, and it's real estate. Buying a house from the owner, renting with the option to buy contracts. Is it legal to sell your contract to purchase a house to someone else? I'm telling you, y'all, better. This is why this class is so important, and I'm so glad to be taking it. It's because in my life, I just, I don't do this kind of stuff, but these other people, oh my God, this is what they do. And you need to know. You need to know, honey. Looketh before you leapeth. Okay? Finally, we want to consider the relationship between closing conditions on the one hand and the indemnification on the other. What happens if, let's say, I close a deal, but I'm aware of a material breach of a rep or a warranty? Accuracy is a condition to closing, but I decide to close anyway. Can I still bring a claim afterwards under the indemnity against the car seller for this breach? This breach that I've decided to neglect put aside, and close on anyway. This is a practice that's sometimes referred to as sandbagging. Sandbagging. Let's go all the way in. What does sandbagging someone means? It means to hide your true abilities or purpose in order to deceive people, gain an advantage. Reminds me of gaslighting, honey. These things are not good. Under Quora.com it says to sandbag someone is to coerce or bully someone. It's a North American colloquialism or slang. Okay. Let's say in business, sandbagging is a strategy. It's a strategy of lowering the expectations of a company or an individual's strengths and core competencies in order to produce relatively greater than anticipated results. Why is it called sandbagging in sales? The term sandbagging comes from the late 1800s and refers to somebody who sneaks up on someone else and hits them with a sandbag. In today's sales world, sandbagging is used to describe a representation holding back his deals a bit and fooling their manager into thinking that their forecast is worse than it actually is. This is done a lot. This is done a lot. And is done on purpose to sabotage co-workers, to sabotage managers and directors by purposely reporting wrong information. It's a deception. Oh my God, these people. So let's go back here. Professor Whitehead says, accuracy is a condition to closing, but I decide to close anyway. Okay, I'm aware of a material breach of a representation or warranty. I decide to close anyway. Can I still bring a claim afterwards under the indemnity against the car seller for this breach? This breach I've decided to neglect, put aside, and close on anyway. This is a practice that's sometimes referred to as sandbagging. And as the name suggests, is generally not considered to be a best practice. If I know of a problem, the expectation is that I'm going to raise it because it's a condition to closing. I'm going to raise it before the closing takes place. But what if I wasn't fully aware of the problem, or because I really needed that car, I decided to close anyway? Can I now bring a claim against the seller under the indemnity? And the answer is it depends. It's going to depend on the governing law, which varies from state to state and usually county to county. It varies from country to country. It also will depend upon what's in the contract. Sometimes it's clear that the buyer still has a claim under the indemnity. The contract is clear on this. Even if the party has notice at the time of closing that there's been a breach, but it closes anyways. Sometimes, although much less often, the contract will make it clear that the party who closed no longer has a claim, but more often than not, the contract is silent. It actually doesn't have a provision that speaks one way or the other. And so the law governing the contract becomes important in deciding whether or not a claim survives. Another thing is usually a seller who is a business owner will work with you. They will work with you. They will come up with some type of a compromise. Okay. If they do not, then it's just lesson learned. Lesson learned. So that was how the components of a contract work together. Professor Whitehead, Cornell University Law. Ta-da! All right. Talk to y'all later. Bye.